coupled with the fact that when you actually litigate a patent case to judgment, about half of all patents turn out to be invalid, means that in a lot of industries, the way people innovate is by ignoring patents. They get a bunch of them on their own, which sit on a shelf to make sure that nobody else in the industry sues them. But they don't use patents as a driver for innovation. In fact, patents in those industries are often a blocker for innovation. So I think these differences explain a fair bit of what's been going on in modern politics around the patent system. We're in our 7th year of trying to pass patent reform in Congress. At every turn, the biomedical industries and the information technology industries have been at odds, not only over large issues like do I get an injunction when I win my patent case, or how do we calculate damages, but even obscure issues that only a patent lawyer could love. Like, what's the right interpretation of Section 271F of the patent statute dealing with circumstances in which you export components of a patented product separately in the United States, intending that they be combined abroad into an infringing product? Or when should we enforce the best mode doctrine of patent law that says that you, in addition to teaching us how to make and use the invention, have to tell us the preferred methodology that you used for implementing that enabling disclosure. So we've got a sort of fundamental fight, fundamental differences. One of the things we've seen in the patent law, in the patent reform area, is that during the time that Congress has been unable to come to agreement on any of these things, the courts have actually been fixing a lot of these problems. And the courts have been fixing a lot of these problems not by picking a side, not by saying, yeah, you know what, IT's right and pharma is wrong, or vice versa, but by saying we can decide on a case-by-case basis that different results are appropriate in different circumstances. We can take account of the differences in the way the patent system works for innovation in different industries in deciding whether or not to grant an injunction, in figuring out how we calculate damages, in a variety of other areas. And what I want to suggest is that the antitrust intellectual property overlap needs to take the same basic step. We need to take account of the fact that the relationship between market structure and innovation differs by industry, that it differs by technology, and we need to recognize that sometimes Schumpeter's right and sometimes Arrow's right. Well, how do we do that? You know, one thing you could do, just as one thing you could do in the patent world, is you could pass industry-specific antitrust statutes. I'm not a big fan of that approach. We have some of those things. We have insurance exemptions. We have railroad exemptions. In general, I think they're a bad idea for a couple of reasons. One is that they promote very specific private interests, and so they're much more likely to be the subject of industry capture. The second is that they're things that Congress might do periodically as things are brought to them, and they're unlikely to be forward-looking. And where we're concerned, not with static efficiency, but with new technologies, with changes, it's unlikely that we're going to get a set of statutes written with particular industries in mind that's actually going to be timely and focused on new developments. But I do think that, just as in intellectual property law, the courts have had the ability as a common law matter to make industry-specific distinctions and technology-specific distinctions. So too do the antitrust laws. Antitrust law is already industry-specific in important ways. Not in the statute, of course. The statute's quite broad in general, but in the way we apply it. Right? We have a whole series of circumstances in which we simply do things differently, sometimes expressly by industry or technology, in the antitrust courts. The Microsoft case in the DC Circuit created a whole new set of tying law rules for operating systems in computer software. We have a set of new rules that apply in circumstances where there are particular types of regulation. Antitrust says we're going to treat telecommunications antitrust cases differently. We're going to treat securities industry antitrust cases circumstances differently because of the presence of regulation in those industries. We have a special set of judicially created rules that govern one particular set of complex multi-party agreements, that is to say, collective bargaining by unions. And we also have, I think, a sensitivity in antitrust law that comes out of the relevance of economics to changes in the economic characteristics of particular industries. We will pay attention to network effects in things like deciding whether or not Visa and MasterCard have violated the antitrust laws by imposing particular rules. And in fact, we've got such an industry-specific focus without really thinking about it, right, that the enforcement agencies have structured themselves not in terms of the law, but in terms of the industry. Right? The FTC and the DOJ don't divide things up by saying you take monopolization and we'll take cartels. They divide things up by saying you focus on industry X and we'll focus on industry Y. And that, I think, is quite remarkable. Right? And even within the DOJ, you then see sort of subgroups divided by what industry people are focused on. So I think there's room for antitrust law to sort of think about antitrust intellectual property in an industry-specific way. But I think to do so, we've got to stop thinking about antitrust as merely about static efficiency, as merely about sort of regulating how we treat existing products, and as not having anything important to say about how we get new products. A co-equal antitrust, a full partner antitrust in this relationship, I think would end up doing substantially more than antitrust today does to intrude on decision-making that we normally think of right now as patent law decision-making. Right? It would be, I think, first off, at the sort of fringes, it would be more willing than it is to look into the economic characteristics of a particular patent pool, let's say, or standard-setting organization, or private settlement of litigation. And ask, is this in fact something that is necessary to promote innovation, or is it something that is not likely to promote innovation and is interfering with competition? Similarly, mergers and acquisitions, I think, are an area in which antitrust law could have more to say about the role of intellectual property. Judge Posner, nearly 30 years ago, wrote in the Brunswick versus Regal case that doesn't matter who owns a patent's a patent, it's got a right to exclude, end of story. Antitrust has nothing to say here. I don't think that's right. It's not right to say that granting this particular right is going to have no different effects depending on whether you give it to a non-practicing entity or a small upstart competitor or a dominant market player. And so I think antitrust law has a role to play in deciding under what circumstances we ought to be passing intellectual property rights from one to another. And finally, and more controversially, I think there may be circumstances in which antitrust law actually has a role to play in the core area of intellectual property itself. Right? That antitrust law may be able to say in certain extraordinary circumstances, yes, you have an intellectual property right granted you by the Patent Office, but we think that right is actually invalid. And that if we can demonstrate that fact in court, certain consequences ought to flow from it. Or yes, you have an intellectual property right, but we think that the enforcement of that right in a particular way, or the licensing of that right in a particular way, is going to cause problems even if that patent right is valid, and we can step in. So let me close with my favorite antitrust intellectual property case. This is a case from 1610. So before the statute of monopolies, patents were rampant at this time. Patents were government grants from the Crown in England, sometimes for the purposes of encouraging innovation or at least importation of new technologies, but sometimes as personal favors to friends of the king. And so let me tell you about the case of Mompesson and Mitchell. Mompesson and Mitchell held the patent for the exclusive making of gold lace. In patent gold lace in England. They, according to the reports, grossly abused this patent, not only enforcing it against others, preventing others from making gold lace, but then making lace themselves as the ones with the exclusive right to do so of base materials that weren't gold. So we prevented other people from doing this thing, and we adulterated our own technology. What happened? Well, people got upset about this. Mompesson and Mitchell were charged with patent misuse. And as a result of being charged with patent misuse, they were fined £1,000, which back in 1610 was a substantial amount of money, stripped of their knighthood and their lands, forced to ride through the streets of London on a horse with their head to the tail, and imprisoned for life. Now, I don't think antitrust is anywhere near that. I understand we might have a disgorgement remedy this week, although even that turns out to be controversial. But I think the notable thing about the Mompesson and Mitchell case, besides the change in remedy structure in the last 400 years, is the challenge. The argument for Mompesson and Mitchell was not that you didn't have a patent, but that what you were doing with your patent wasn't actually promoting innovation, wasn't actually promoting what we were supposed to do. A co-equal antitrust, a partner in this antitrust intellectual property relationship, is one that can say, in appropriate circumstances, antitrust, competition, and not innovation is best going to promote intellectual property here, and the law should reflect that fact.